please identify themselves in this case?
Attorney George Wattendorf to the state.
Good afternoon.
Joseph Hart.
Good afternoon, sir.
Bradley Jardis for Mr. Hart.
Good afternoon, Mr. Jardis. And I will note, as is apparent in the record, Mr. Jardis has been approved as a Rule 1.3D non-attorney representative for Mr. Hart. Okay, so we're scheduled for trial. There were some pre-trial motions that the court ruled on. Did both parties get my orders on the two motions to dismiss, the motion to compel discovery, and then the motion to suppress?
The state has received them.
Yes, Your Honor, but I would ask, I filed the motion to suppress. Did that come through?
It did, and I did have an opportunity to rule on that, though my ruling is, let me read it to you. As this is a motion in the nature of an evidentiary objection, it will be addressed at trial if the state seeks to introduce the evidence.
Thank you, sir.
So, everybody has the rulings. The state did file on May 16th a complaint amendment form for the disorderly conduct charge. Mr. Jardis, Mr. Hart, you can go ahead and have a seat.
Thank you.
Mr. Jardis, did you have the opportunity to review that with your client prior to today?
Yes, Your Honor.
Okay. And any preliminary issues before we get started with respect to that amendment?
No, sir.
Okay. Any other matters of a preliminary nature before we start the case?
I don't believe so.
Okay. Seeing none, state can call its first witness.
State calls Vernon Puslin.
And I should ask, I guess, does that either party know of anyone in the courtroom who's gonna be a witness who ought to be sequestered?
I have two officers.
Okay, and they're out in the hallway.
They are in the back.
Okay. So
Guess you guys need to step
I'm gonna proactively invoke Rule 615 and ask anyone who might be a witness in this proceeding to step out. That way the witnesses can't hear each other's testimony, which will help me to judge their reliability. Are there any witnesses in the courtroom for you aside from your client?
Just Mr. Hart, sir.
May I
Why don't you go ahead?
understand
Go ahead.
that there's
Step up.
Davids and other people here that witnessed it?
Right, but we're not calling this
We're not gonna call them? Okay.
So no one besides your client?
That's correct, sir.
As long as they don't talk, though.
All right.
They don't talk. Okay.
If you raise your right hand, you swear or affirm the testimony you're going to give today shall be the truth under the pains and penalties of perjury.
Swear to God I will.
Okay, you can have a seat. Please state your name and spell it for the record.
Vernon Puslin, last name Pousland.
All right, you may inquire, Attorney.
Thank you. Could you tell the court how you're employed?
I'm employed with the State of New Hampshire Judicial Branch.
Okay. And what are your duties?
I'm a court security officer here in Hillsborough at the City Circuit.
Is that where you're mainly assigned?
Yes,
Those
it is.
duties? Okay. And what are your duties in general as a court security officer?
Safety and security of the court, all court staff, all constituents, general public, and general court security.
Okay. Were you on duty on February 6th?
I was.
2024 at 1 p.m. on
I
that
was.
day? Okay. Where were you? at
I
that
was here in the courtroom getting ready to, a trial was just getting ready to start.
time? Okay. What trial was that?
It was a Mark Mansion trial.
Okay. And did something out of the ordinary occur at that time?
Yes, the clerk of court had handed me a document. One of the documents, we have people that want to record in the courtroom, they have to fill out a piece of paper in its entirety. The clerk handed it to me and told me that the person that filled it out was not allowed to record in the courtroom because the form was not filled out completely.
What did you do with that form?
I showed it to Mr. Hart, who was at that time recording. I asked him to cease recording or leave 3 or 4 times. He refused to do so. And at that point in time, he was criminal trespassing, and he was arrested
By?
by Sergeant Bannister and Officer Davey, if I remember correctly.
Do you recognize that person that you testified to as Mr. Hart? Is he in the
Yes, he's sitting
courtroom
in the
today?
court in the gray suit and the blue tie.
Okay. For the record, show that that is the defendant that he was identifying?
I think they both have blue ties. Perhaps you could offer
With
another
the
identifier.
yellow tinted glasses?
Any objection?
No, sir.
Okay, without objection, the record will reflect that the witnesses identified the defendant as the person who was arrested by the police that day.
Okay. I'm going to show you a form at this time and ask if you recognize it. May I post the witness drawing?
You may.
Yes, this is the standardized form that we ask people who wanna record in the courtroom, to fill out.
Okay, was that the form that was handed to you that day by the clerk?
It was,
And was that the form that, Mr. Hart submitted to the court that day?
correct, yes it was.
Now, at this time, the state would ask to admit State's Exhibit 1, which is,
May I see it?
which is the form that was just identified, and it is a certified court record.
This is not the form they gave me. This is not the copy. This is not it.
I don't think this is a truly tested copy by the clerk.
This is not the one they gave me. I'm telling you right now, this is not the one you gave me.
There's really little.
I'm just saying, that's not the one they gave me. I can't say yes, it is.
Okay. So at this time, the state offers State's Exhibit 1, which is a certified court record from the clerk.
Is there an objection, Mr. Jardis?
Well, Mr. Hart does claim that this is not the form that was presented to him. We had a discussion about this a few months ago. I have no way to verify whether it is or not the correct form. I mean,
Well, I think that will go to the weight of the evidence rather than his admissibility. The witness has testified that he's identified this form as the form that was handed to Mr. Hart. It bears the raised seal of the court as a certified court record.
It's my handwriting, it's everything.
I think
correct,
it's met the
but that's
grounds
not the
for
copy I got.
admissibility. Whether, what weight I give to it is certainly an ultimate question of fact.
Okay.
Unless there's any further objection.
no, sir.
All right, the amended State's 1.
Just bring up my question. Bring it up here.
Okay, as a court security officer, were you instructed to follow a certain Supreme Court order dealing with individuals who are videotaping in the courthouse?
Correct, yes.
And I'm going to show you another document. And ask if you recognize it, and if so, would you identify it for the court?
This is the order that came down from the Supreme Court about recording.
Okay, do you follow that, were you instructed to follow the instructions on that?
Yes, sir.
And could you basically summarize to the court what your instructions are if a person is videotaping or wants to videotape in the court?
They need to fill out the proper form from permission from the presiding justice of that courthouse. And if it's granted, then they're allowed to come in and record it. In this case, Mr. Hart's request to record the courtroom was denied by Judge
Okay, and
McIntyre.
what procedure are you instructed to follow if they are recording without permission?
I'm asked him to cease recording or leave, and I did that several times.
Okay.
I should have forwarded this to you already.
Yes, we'll assume that's accurate.
At this time, Your Honor, the state would seek to admit as State's Exhibit 2, a New Hampshire Supreme Court order, which was issued on November 16, 2021.
Objection, Mr. Jardis?
No, Your Honor.
Without objection, to the amended State's Exhibit 2.
Okay, what happened when you told Mr. Hart that he needed to stop recording and leave the courtroom, and he refused?
He refused holding up the paper, saying something about he doesn't have to fill it out completely or something to that effect. I can't recall exactly what he said.
Okay. What happened next? Did you witness law enforcement take action?
Yes, that's when Sergeant Dancer and Officer Davey, stepped in to arrest him to cease recording or leave. He did neither.
Okay. I have no further questions of this witness.
Okay, Mr. Jardis, do you wish to cross-examine?
A few questions, Your Honor.
Go right ahead, and you're free to use the podium if you wish.
Oh, thank you. Officer, do you know why Mr. Hart was so upset that day when you confronted him and asked him to stop filming?
I do not.
You don't? Your Honor, I have 3 forms that I would like to introduce as evidence. They are from the Goffstown District Court, 2 from Goffstown, actually all 3 are from Goffstown, And they are advance notice forms that were filled out by Mr. Hart in a manner that he filled out the same day that he was here. Our defense, of course, is 626.3, paragraph 2, prior grants of permission. And
Are you gonna lay some foundation for these forms with this witness?
a little bit, yes.
Well, if you can lay a foundation to authenticate them, then go right ahead.
Okay, may I approach the witness?
Of course.
Okay. Officer, I'm gonna hand you 3 forms.
Yes, sir.
And I would ask if you could take a look at them and tell me if they look like standard forms that are issued by the court.
They look to be the same if that's your question.
Yes, can you tell the court what the forms show?
One seems to be filled out properly, the other 2 do not.
Okay, these forms, when they are approved, how are they approved exactly? Like what is, does it,
They're given to the clerk of court and then she reviews them with the judge.
okay, but when they're approved, are they signed, are they stamped?
The only one I've seen was the one from Mr. Hart. That's the only one I've ever seen.
Okay, so these forms, you can't say whether or not these forms are approved or not?
I cannot.
Okay, all right, thank you. Your Honor, I appreciate the leeway you're giving me as I'm not a trained attorney and I'm doing my best to help my friend here. We intend on laying the groundwork when he testifies, as he will testify, to show that these forms were filled out by him in the past, albeit in a way that was ruled improper here in the court in Hillsborough. But when he filled them out before, he filled them out as breaking the flaw, which is his organization, Anon and Anonymous, which is the same way he filled out the forms on the day that he was arrested here.
Okay, so you're telling me you're gonna lay additional foundation to show that these were forms filled out by Mr. Hart at some
Correct.
prior time? So your client has no obligation to testify, has an absolute right to remain silent. I wouldn't draw any inference, but you're free to attempt to lay additional foundation when you have witnesses to
Okay,
testify.
okay, thank you. So would you prefer I wait to introduce this when I get some more information from him?
Well, the only foundation I have is what the witnesses testified. It was just that they look to be the same type of form, but he's not able to testify about who got them or what they got them, and your representations, they aren't evidence yet, so I wouldn't find there's sufficient foundation yet,
Okay,
but certainly you can continue to try to lay that foundation.
okay, I will lay that very firmly with Mr. Hart when he takes the stand.
Of course.
Thank you.
Do you have any other questions for the witness?
No, Your Honor.
Okay. Any redirect? No. All right. You are excused. Thank you for your time today. Please, you can step down. You can leave the courtroom. However, please don't discuss your testimony with any other witnesses until the trial has concluded.
Yes, sir.
Thank you.
State calls Tyler Davy.
Okay.
No.
Officer Davey?
So if you take the stand, and please remain standing and raise your right hand. Do you swear or affirm the testimony you give today shall be the truth, understanding, and penalties of perjury?
I do.
Okay, you can have a seat. Please state your name and spell it for the record.
Officer Tyler Davy, spelled D-A-V-Y.
You may inquire.
Thank you. Officer, you're employed as a police officer in Hillsborough?
That's correct.
And how long have you been employed as a police officer?
I've been employed approximately 4 years.
Okay. And you're certified by the New Hampshire Police Academy?
That is correct.
Okay. Did you have occasion to be present at the Hillsborough Sixth Circuit Court on February 6, 2024, at approximately 1 p.m.?
I did.
And why were you there?
It was for a scheduled trial.
Okay. And you were a witness in that trial?
I was.
So how were you dressed?
I was in court attire, suit and tie,
Not your uniform.
not my uniform.
So you would not then have a body cam on your person?
That's
Is that
correct.
accurate? Okay. So at that time, do you recall, you were in the courtroom, you state?
I was.
Do you recall an incident occurring shortly after 1 p.m. that happened inside the courtroom?
I do.
And could you briefly describe what you observed, please?
I observed a male individual who was seated in the gallery area, utilizing a cell phone to record. He was told by one of the court bailiffs to, either shut his phone off or leave, and he refused.
Okay, and, observing this as an officer, what, action did you take and why?
So after he was told, to either shut his phone off or leave, he refused. And me being employed as an officer, I subsequently stood up, went over to him and placed him under arrest for
For-
criminal trespass.
Okay, and that happened in your presence?
It did.
Oh, so what happened next?
So after he was placed under arrest, he was handcuffed behind his back without issue. I escorted him out from the gallery of the court, to outside, to wait for a transport cruiser.
Okay, just to be perfectly clear about everything, there was another officer accompanying you with, this arrest,
There was, yes.
and that person is,
That officer was Sergeant, Bannister of the Hillsborough Police.
once you took him out into the lobby, what happened?
So after I took him out to the lobby, I escorted him out, of the court, to the front entryway, to wait for the transport cruiser.
Okay, and describe the area that exists there once you're outside of the courtroom.
So immediately after you walk out the front doors to the courtroom, there's multiple commercial businesses, such as Subway, New Hampshire State Liquor Store. Directly next to it is a Bar Harbor Bank and a doctor's office.
Okay, and you have an estimate of the size of the parking lot, roughly? I know you haven't measured it,
Pretty large parking lot.
and was things look pretty busy at that time? Or how did it look?
At the time, it did appear busy, lots of, people, conducting their normal business, going from one place to another.
How was Mr. Hart conducting himself at this time?
When we were outside, he was continuously yelling, and swearing profanities. Multiple times he said, I do see there's children in the courtroom. I don't know if you'd
So-
like me to say the words specifically.
The obscenities, well, I guess we don't, well, yeah, we're gonna have to testify about obscenities, so.
Well, so if there's any parents in the courtroom who'd ask want their children to step out, but, all right. I think it needs to be in the record, so if you could answer the question, please.
Absolutely, Your Honor. He continually was saying the word, fuck.
When you say he was saying it, how was he expressing it?
He appeared, agitated and upset.
What was the volume?
It was pretty loud. I noticed while he was continuing to yell and swear, there were two people, walking towards the bank, who actually stopped and looked at us.
Objection, Your Honor, that would be hearsay, as it's a nonverbal conduct that's meant as an assertion.
At this time, Your Honor, don't believe that meets the hearsay. He hasn't said what those people said. He's just testifying that he saw people crossing the park.
So under Rule 801, which defines hearsay, as Mr. Jardis has pointed out, it can be a verbal or non-verbal assertion, but it has to be intended by the declarant to convey a meaning. Based on what I have heard, and this may go to whether the state can prove the Murray issue, just testifying that someone looked in his direction isn't conveying any type of meaning, at least not that, that I would say. I can't say that the witnesses, the people who walked by, intended any meaning by it, but they looked that way. So I don't find it's hearsay. So I overrule that objection.
Alright, so while this was happening, did you say anything to Mr. Hart?
I did.
What'd you say?
I told him to cease and desist the continuous yelling of profanities, or he would be arrested for disorderly conduct as well.
What was his response?
He responded by saying, go ahead, fucking do it, fucking charge me with this disorderly conduct, do it, do it.
And is this what volume was this being expressed in?
It was in a pretty loud volume, I would say.
Is it your testimony that other people could hear this in that parking lot area that you've testified about?
I would say so.
Whoa, that's an objection right there.
Do you see the person that you arrested in the courtroom that day, present in court today?
I do.
And would you identify him, please?
He is sitting next to Mr. Jardis wearing a gray suit and tie.
No further questions?
Is there any objection to the identification?
No, Your Honor.
Without objection, the record will reflect that the witnesses identified the defendant as the person who you arrested. Mr. Jardis, cross-examination.
Yes, sir. Good afternoon, Mr. Grady.
Good afternoon.
You said I would say so, in response to the question of, forgive me, I don't remember the exact question, but it was, would you say that people were disturbed? And you said I would say so.
That's correct.
Okay, so, I mean, it doesn't sound very confident. You would either yes or no, people were disturbed.
Yes.
Yes. Okay, how do you know people were disturbed?
Since the two people walking towards the bank stopped what they were doing, which was walking, and looked towards my direction.
I've arrested my fair share of people in public, and I've found that arresting someone is interesting, right? I mean, people tend to look at, if you make an arrest, people are gonna look and see what you're doing because it's interesting. The police are interesting. Would you say so?
Yes.
Can you say what the people were thinking when they turned to look at what was going on?
I cannot say.
So you can't say whether or not they were disturbed. Were you disturbed?
I was not disturbed.
You're not disturbed. So you can't say whether or not they were disturbed that someone was using profanity in public, or that they were simply interested in someone being arrested. Is that correct?
I'm sorry, a little confused at what you were trying
Okay,
to say.
maybe I word salad that, but is it fair to say that you cannot differentiate between whether or not someone was interested in what you were doing as you were arresting someone in public, and you can't tell whether or not that what those people were actually doing was being disturbed by what he said because you're unable to read their mind? Is that correct?
That's not correct.
Could you correct me?
Yes. So when those two people that I saw were walking towards the bank and they stopped and looked at us, rather than just continuing on and looking, they stopped. So it essentially hindered as to where they were going, what they were doing.
Okay. Can you identify the people who stopped to look?
I cannot.
You cannot. And I'm not trying to pick on you. I've been in heated situations too, and your security of the prisoner is paramount. But can I ask why you didn't get their information so we can have a constitutional response to the charges?
Because at the time I could not leave the prisoner unattended, Mr. Hart unattended while he was handcuffed. That would be a liability on his safety and policy.
Okay, thank you very much, Dr. Gates. Thank you, Your Honor.
You
Would
redirect.
you agree with?
Yes.
Okay.
No redirect, Your Honor.
Same case.
I wanted to,
I'm disturbed. I am.
So, did you have questions, or
No.
may the witness be excused? All right, Officer Davey, thank you for your testimony today. You may be excused. Please don't discuss your testimony with any other witnesses until the trial has concluded.
Yes, Your
You
Honor.
can go ahead and head out the door. Thank you.
I actually don't have any more witnesses to call, so,
State rests.
the state rests. You can sit in the courtroom and.
Okay.
Well, in case he may be called as a rebuttal witness.
Oh, okay.
I'll have you wait outside, just
Yes, Your Honor.
to be on the safe side.
Your Honor, the defense calls Mr. Hart.
Okay, Mr. Hart, please take the witness stand, remain standing, and raise your right hand. Do you swear or affirm the testimony going to give today shall be the truth under the pains and penalties of perjury?
Yes.
Okay, you can have a seat. Please state your name and spell it for the record.
Joseph Hart, Joseph Hart.
Good afternoon, Mr. Hart.
Hey.
As you heard me ask the very first witness, I showed him, 3 forms. I would like to show you these 3 forms and ask you what they are. May I approach him, Your
You
Honor? Can you please look at these 3 forms and explain to the court what they are and how they came about to being in your possession?
Sure. This is a form I filled out dozens and dozens of times, even one with you, Judge, anonymously. And it was, it's always been approved, just like these 3 forms here.
Okay.
Yes.
So when you say these forms were approved, what on these forms lead you to believe that they were approved?
Well, it says approved. It says received, no objection, received, no objection, received, no objection from prosecutor or defense in the cases.
And can you please explain to the court how you filled out these forms exactly?
Yep, not with my name, I used anonymous, anon, and my, organization Breaking the Flaw.
May these be introduced as evidence, Your Honor?
State checks.
It's a very severe objection.
Relevancy, number 1. The relevancy is, it appears that he is introducing these for his estoppel defense. And it's not relevant to the criminal trespass or the disorderly conduct. It might be relevant if he was charged with violating a court order regarding videotaping, and it was part of a contempt proceeding. I could see the relevance here. But this is not what he's being charged with. He's being charged with trespassing, refusing to leave when he was told to do so by an authority, and disorderly conduct, recklessly creating a risk of breach of peace. None of these documents don't pertain to that defense.
Mr. Jardis?
Well, Your Honor, effectively, what I'm trying to get at is the reason why Mr. Hart was so upset that day is because of past grants of permission to engage in this type of behavior from other courts similarly situated to this court. Although we only have 3 forms to show you today, Mr. Hart has testified that he's done it more times. I know we have it on video where he did it in Keene District Court, and he's been allowed to film without filling out these forms completely. So yes, the entrapment by estoppel, which you addressed in your opinion, and the RSA 626.3(2) defense for prior grants of permission is particularly relevant. And I understand Mr. Attorney Wattendorf doesn't think that they're related, but if you think about it, the only thing that changed that was different once he was told to leave, the only thing that predicated that was him filming. And if he had not continued filming, he would have not been an unauthorized person and been required to leave. So he was filming because he had been given permission in the past to film in this way, and that's why he was so upset, and that's why everything happened the way things went out. I mean, he thought he was being targeted, and that's what I'm trying to show you through the 626.3(2) defense.
So the definition of relevance is fairly broad. It's defined as any evidence which has any tendency to make it a fact an issue more or less likely. I can see some relevance to the issue of the mental state. There's a knowingly mens rea. So I think it's admissible for that purpose to show the effect on Mr. Hart and his mental state. I'm not making any rulings on what legal defenses would apply, but I do think there's at least minimal relevance, and that's the only standard that has to apply for relevance, if that's the only objection, so.
Want to see them?
Sure.
Hey, Brad.
Your Honor, may I approach him real quick?
Does he need some,
Yes.
What do you need, sir?
I just wanted to talk with him for just a moment.
Well, when you're being examined.
Okay.
You don't, once you take the witness stand, you
Right.
can consult with your lawyer about your testimony.
We'd have to
right?
take a break at that point.
Well, the point is that once you start getting examined, you're not gonna be allowed to talk to your lawyer to kind of shape the next steps, right? It helps me.
I understand. I
So,
understand.
you'll have a chance to talk to him after you've been
Okay.
examined.
I don't see on any of these forms where it was granted.
Well, what,
I just
may I see the exhibits?
Yes, may I approach you, Your Honor?
You may. So,
The fact that they were stamped, Your Honor, and then Mr. Hart can testify that after the stamping, he was allowed to film.
well, yeah, I mean, I think whether they were approved, or, right, I mean, that's his testimony, is that his perception was they were approved. I think, again, it goes to weight whether they were marked in any particular way that would indicate that they were appropriate or not. But I think that's a weight, not admissibility, so.
Thank you, John.
Anything further?
No, sir.
So these will be marked as one exhibit, which will be defendant's exhibit A.
So, Mr. Hart, when the officer told you to leave, I can see the court being a little remiss to sort of greenlight this type of behavior where if
I
I.
object, it's a leading question.
So,
What, may I
you're doing a
rephrase that?
little bit of argument, Mr. Jardis, in your questions. I've given you some leeway since you're not an attorney, but just who, what, where, when, why, how. You'll have a chance to argue at the end.
I like the argument part, Your Honor, thank
I
you.
can tell. Go
Um,
right ahead.
Were you upset when you were told to leave?
Yes, yeah,
Why?
because I'd been doing this previously, even once before with this judge anonymously, and many other judges, approving it, and I felt like I was within the right to do so, and, it was surprising to me that I wasn't.
Would you say that you were mistaken about that?
Yes, yeah.
No further questions, Your Honor.
Cross-examination.
So, you don't deny that you were given the form that said denied, that you did not have permission to record.
But not denying that, yeah.
And you're not denying that you were told by the bailiff to leave, if you were not gonna stop, if you did not stop recording, that you were gonna have to leave.
I felt like I was in the right,
Yep. And, but you don't deny that that happened,
not denying it.
and you agree that you refused to leave after being told to do so.
Yes, yeah.
And, when you left the courtroom, you were still pretty upset, sounds like.
Yeah,
Yep.
absolutely.
And you don't deny that you were yelling obscenities out in the parking lot,
I wouldn't say yelling. I'm just loud.
just loud.
I mean, if you want, I can exercise what yelling sounds like in here so we can tell the difference. And maybe with the witnesses here.
You speak in a loud enough voice so that people within 100 feet could hear you?
I cannot testify to that. I have no idea.
Okay, but it's loud. You were told to stop, right? Or you'd be charged with disorderly.
The cops can't be victim of disorderly, so I was like, go ahead. Right?
So your answer is yes, you refused to
I
stop
continued.
yelling obscenities.
Yelling, no.
Shouting,
Not shouting. I'm just loud.
so really your whole issue before the court is the ability to film court proceedings. That's,
Can you repeat that, please?
yeah, so your issue before the court today is that you should have the right to film court proceedings, regardless of how you fill out the form. You have that right.
At the time, I believe that I filled out the form properly.
Yeah.
Is that what you're asking me? I'm not sure.
Yeah, I'm asking you about video taping recordings.
I believe that I filled out the form properly at the time.
Yeah, and so your, reaction when the bailiff told you to leave was basically being upset about the court videotaping policy, isn't that correct?
No, I'm okay with the court's videotaping policy. Like I said, I thought I was doing it within the right.
Well, then when you were denied, then you should have left, is that right?
Well, I
In this
thought that I
case-
was in the right, so I continued to do the process.
So rather than, you did have an opportunity to request a hearing with that judge or a reconsideration of that ruling, isn't that correct? You know enough about court
I
procedure,
mean, I would
right?
come back and say that maybe the court bailiffs could have corrected me and versus just, threatening me.
Right, that wasn't my question.
I know, but
You
my response.
you know that you have a right to request a reconsideration or a hearing with the judge about your denial. Right?
I am not familiar with the hearing, you saying?
Yeah, reconsideration of
Regarding recording in court, you saying?
the denial.
The denial?
Yeah, you could have asked the court for reconsideration on that.
Well, I mean, couldn't the court ask
No,
me
that's
to
not the question.
I know, but I'm just saying, like, I don't know the process to that level, but I know that the court could have told me how I did it wrong.
If,
Mr. Hart, understand that you've got an argument that you gotta
Yeah.
make, and your attorney will have another chance to ask you more questions, but if you could just try and listen to the question,
Sure.
if you can just answer it yes or no first, and then your attorney can ask you further questions if he thinks
Okay.
you need to clarify.
All right.
So why don't you ask the question again, attorney?
After being denied, you had an opportunity to request a hearing before the judge or for reconsideration of that ruling denying you.
I would say that there's many opportunities after that point. I don't know exactly which one would have been the right avenue.
I have no further questions.
Okay. Redirect, Mr. Jardis.
So security told you to leave and you refused, correct?
Correct.
Did anyone in the court take any time to try to explain to you what you had done wrong and what you would need to do to correct it?
No? No?
So you were just presented with the form, you were told this is denied, and you have to leave.
Correct.
So, but you kept filming, and I understand where Attorney Weindorf is getting at here, and I'm sure you do too. You kept filming even though you were in defiance of an order to leave. Can you just repeat again for Judge Gupta why you thought that was appropriate to do?
Because I had previously done it, and that filled out the form the same way, including with this judge here, and I believe in Keene, which was approved. So I assumed that this was a proper way of doing things, and I came in and continued recording.
Did you feel like you were being targeted?
This is potential. This is definitely potential. I've been assaulted by bailiffs. I've been run down in parking lots by bailiffs. I've been threatened by bailiffs, including prosecutors, threatened by prosecutors, threatened by, and all kinds of things. Like, I've never ever experienced this sort of level of insanity on a state level as I've done in New Hampshire. But back to the question is that, yeah, I feel like, it's just not been like accurate. Like, the system here, I felt was doing it wrong, so I continued to do what I was supposed to do.
Do you think if a year prior in a different court where we have records of you being approved, if you were told that the appropriate procedure is to fill out your entire name, do you think Hillsborough would have happened?
I bet you every single one of them would have told me if that was the wrong way to do, but apparently they didn't, and this court did it correctly, apparently, so, yeah.
Okay, no further questions, Your Honor.
Okay.
Thank you.
Mr. Jardis, does the defense have any additional evidence?
No, Your Honor, just a closing statement.
Okay, does the defense rest?
We rest, Your Honor.
Okay, so the New Hampshire procedure is the defense goes first, state gets the final word because they have the burden of proof. Mr. Jardis?
Judge Gupta. The case before you today involving Mr. Hart is not one of a man who came to this court facility looking for trouble. To the contrary, Mr. Hart came to this court facility looking to conduct his routine activism, which is being a member of the Free Press. On February 6th of this year, after filling out the advance notice form in a similar manner to the way that he had been doing for years, Mr. Hart reasonably assumed that due to past grants of permission to film that he would be authorized to film once again. When confronted by court security that his form was denied, knowing that he had been approved many times before, Mr. Hart became understandably upset. He knows that there is very little discretion allowed on an individual court to restrict his ability to audio and video record. Because of these past grants of permission, Mr. Hart truly believed the Hillsborough District Court was infringing on his First Amendment and Part 1, Article 22 rights to be a member of the Free Press. It is true, Mr. Hart did stand his ground. Mr. Hart is not like a normal citizen in that he is a professional activist who is educated in what his legal rights are. Many noble activists have stood their ground when faced with actual or perceived improper authority throughout history. The hill that Mr. Hart chooses to risk his liberty and defend is that of the freedom of the press. Without people standing up for our codified liberties, the liberties themselves would risk being minimalized. Mr. Hart's activism being journalism, he takes it very personally when he feels that his rights to engage in this type of activism are threatened or infringed upon. Now, we concede that the Hillsborough District Court was the only court to require which is appropriate on these forms. That would be, of course, the accurate identifying information. This, however, does not change the fact that his sincere belief that he was in the right was based legally in past grants of permission. RSA 626.3, paragraph 3, and the concept of entrapment by estoppel exist for this very reason. That is, a well-meaning citizen, as Mr. Hart was that day, should not face criminal liability for exercising privileges that the government clearly indicated were available to him. If one single court official along the way told him what he was doing was improper, his arrest in Hillsborough probably never would have happened. This isn't a victimless offense, Your Honor. There is no injury to a person, there is no damaged property, there is no witness to this alleged disorderly conduct. The bail commissioner even got their $40 fee. Since the incident, Mr. Hart is registered with the New Hampshire Supreme Court as a media outlet. He's also now keenly aware that he should fill out the advance notice form. It should be with his valid identifying information. We would ask that you please find him not guilty for any one of the reasons we have argued before you and in our respective motions to dismiss. Thank you.
Mr. Jarvis, Attorney Wettenberg.
Your Honor, the state has offered evidence into court in the form of testimony that Mr. Hart remained unlawfully after being told to leave by an authorized individual, a member of the security staff of the court. By his own admission, he agrees that he refused to leave. As to the disorderly elements, Your Honor, we presented testimony that Mr. Hart was recklessly creating a risk of breaching the peace by making loud noises in a public place, which would disturb a person of average sensibilities, not the police, and did continue to do so after he was requested to desist. And to the estoppel defense, as I said earlier, I believe that that may be a valid defense if you were charged with violating the videotaping policy of the court, but in this case he's not. He's charged with simply trespassing and later disorder.
What do you have to say about the Murray argument?
Murray is very distinguishable because Murray was a case that occurred in, I believe, Exeter, New Hampshire. It was on a motor vehicle stop late at night. There were no members of the public around. There was only the police officers and the defendant. The defendant made a statement to the police officer, something along the lines of, I hope you have a happy Valentine's Day, or something along those lines. And that was the only evidence that was offered in Murphy. And the court clearly said that police officers are not members of the public, and police officers are not somebody under the statute that could be offended. But this conduct occurred in a busy shopping commercial plaza. It's the middle of the day. The officer testifies that he can see people walking close by. We submit that
Objection.
meets
Was
the
not close by.
recklessly creating a
didn't
risk
say
of
it.
breaching the peace.
Alright. So what I'm gonna do, which is what I do in most of my trials, is I'm gonna take a brief recess. I wanna look over all of the evidence. I wanna consider the arguments of the parties. Just take a moment to think about them, because I will get to a verdict today.
Okay.
But we're gonna take a brief recess. Thank you, everyone.
All rise.
It's funny, that same judge gave me approval on an anonymous record request to film in court, guys, so interesting. It's kind of cool I got him as a judge, right? Actually, that was the day that a prosecutor got right in my face, intimidated me physically. We all know Jason Short, right? We would object to that, right?
It being 83.
Well, we should have objected to that from the beginning because we never received that footage, even though we requested it, and they decided to put it up on the screen anyways through the whole time.
It's not going to change.
No, it's not.
It's not like we have a jury.
But it just shows you openness and that we could have gotten this. They refused it.
Everyone can be seated. So I've had the opportunity to consider all of the evidence presented. Mr. Hart, with respect to the charge of disorderly conduct, I did not find that the state has met its burden of proof, and I've entered a finding of not guilty.
Thank you.
With respect to the charge of criminal trespass, I do find the state has met its burden of proof beyond a reasonable doubt with respect to each and every element of the charge, and I will find the defendant guilty. With respect to the mistake of law or entrapment by estoppel defense that was raised by Mr. Jardis, and I thank him for his really well put together pleadings, which laid things out very clearly for me. I don't find that that's applicable because the issue is whether the defendant knew he was not licensed or privileged or permitted to remain in the courtroom at that moment. Whether he believed the court made a mistake in ruling on his permission to film or not is sort of beside the point. And the testimony was clear from multiple witnesses that Mr. Hart was told he was not allowed to, he was given the denial of the form, he was told to either stop recording or leave the courtroom. Multiple times he refused to do so. I was told by an authorized person, the court security officer. He remained in defiance of that order, and that is criminal trespass. So, do the parties wish to be heard on sentencing?
The state would request a $250 fine.
Is there any chance that could be halved? Mr. Hart's working very hard right now and trying to save money.
So, what does Mr. Hart do?
He works as he sells gold and silver.
That doesn't help.
Well, yeah, that's true. Sorry.
So, here's what I will do. I will impose a fine of $500 with all but $150 of the fine suspended for a period of 1 year on the condition of Mr. Hart's good behavior. Good behavior is defined as not committing any felony, misdemeanor, or major motor vehicle offense. Mr. Hart, are you able to pay that fine today?
Yeah,
I mean, I can pay it, but I'm probably not going to.
we're gonna work on an appeal, Your Honor.
That's fine. I can note your appeal. You have 30 days to file that appeal with the Supreme Court. If you do file a notice of appeal, then that would stay the imposition of the sentence. For purely procedural purposes, I just need to put down a time whereby Mr. Hart would pay the fine if he chooses not to appeal. So why don't we make that 31 days from today, which takes us to what, roughly June 22nd.
Yeah.
I will waive the time payment fee because Mr. Jardis has indicated that he intends to take an appeal. There's a $120 penalty assessment on the fine of $400, or a fine of $500, I'm sorry. Do the math. They sent me to law school, not to math school, so. So $96 of the penalty, so $400 of the fine, $96 of the penalty assessment is suspended for a period of 1 year. The condition of that suspension is that good behavior, as I said, defined as not committing any felony, misdemeanor, or major motor vehicle offense defined by statute. Okay, that's gonna conclude the proceedings. Thank you, everyone.
Thank you, Judge Gupta.
Thanks, Judge.
All right.
Thanks for doing anonymous requests. All right, let's go be loud. All right. Well, we're gonna win.